Morning, friends. Ash here, WAT News, with an election update for Pennsylvania and Georgia and others. This article came out of Gateway Pundit. Breaking, huge, Pennsylvania judge rules 2020 Pennsylvania election likely unconstitutional. Trump case has a, quote, likelihood to succeed, gives state legislators power to choose electors. By Jim Hoft. This is huge. Pennsylvania Judge Patricia A. McCullough ruled that the Pennsylvania preliminary election certification injunction was properly issued and should be upheld. McCullough added this, quote, additionally, petitioners appear to have established a likelihood to succeed. Pennsylvania trial court rules the 2020 election was likely unconstitutional in Pennsylvania, and that gives state legislators power to choose electors. Robert Barnes at Barnes Law. So, I believe that Patricia McCullough has an opinion issued at the end of this that we're going to go into, and it's about 8 or 9 pages long, and it's very interesting. So I felt it was important to try to read through it and include it. So it's going to take a minute to do that. Additionally, petitioners appear to have established a likelihood to succeed. More via Rose Tennant. PA legal update. Judge McCullough issues hugely favorable opinion. So this is her opinion that we're going to be reading through here. The thing I'm fuzzy on is that was her particular opinion on it, and I think this particular issue has now been pushed up to the Supreme Court of either Pennsylvania or even all the way to the Supreme Court of the country. I'm not sure where that stands yet, so we'll see how that plays out, and we'll try to get some more info. This is the copy, and I have it pulled up right here, so we can get into that for a second. And this is in the Commonwealth Court of Pennsylvania. The Honorable Mike Kelly, Sean Parnell, Thomas A. Frank, Nancy Kierzek, Derek McGee, Robin Sauter, Michael Kincaid, and Wanda Logan are the petitioners versus the Commonwealth of Pennsylvania. Pennsylvania General Assembly, Honorable Thomas Wolfe, Kathy Bookvar, respondents. Before the Honorable Patricia A. McCullough, Judge. Opinion not reported. Memorandum opinion by Judge McCullough filed November the 27th, 2020. As of this court's November the 25th, 2020 order of an emergency preliminary injunction has been appealed to the Pennsylvania Supreme Court. Okay, so it's been appealed up to the Pennsylvania Supreme Court now. This opinion shall set forth the basis for said order and shall also satisfy the requirements of Rule 1925 of the Pennsylvania Rules of Appellate Procedure, PARAP 1925. The overarching consideration for the emergency preliminary injunction pending the evidentiary hearing scheduled for November 27, 2020 is the compelling exigencies raised in this case, which are of statewide and national concern. Petitioners raise matters that go to the core of the electoral process and involve the constitutionality of how the citizens of this Commonwealth may cast their votes, not only for the offices sought by petitioners, but also for the office of President and Vice President of the United States of America, as well as statewide, regional, and local offices. On November the 21st, 2020, the Honorable Mike Kelly, Sean Parnell, Thomas Frank, all the names I just read, filed a complaint for declaratory and injunctive relief in this court against the Commonwealth of Pennsylvania. The Pennsylvania General Assembly, the Honorable Thomas W. Wolfe, and Kathy Bookvar collectively are the respondents, which this court indicated it would treat as a petition for review addressed to the court's original jurisdiction petition. In the petition, petitioners allege that the act of October the 31st, 2019, PL 552 number 77, Act 77, which added and amended various absentee and mail-in voting provisions in the Pennsylvania Election Code. What is that called? Number 1 is unconstitutional and void ab initio because it purportedly contravenes the requirements of the Pennsylvania Constitution. Petitioners allege that Article 7, Section 14 of the Pennsylvania Constitution provides 2 exclusive mechanisms by which a qualified elector may cast his or her vote in an election. 1, by submitting his or her vote in propria persona, at the polling place on election day, and 2, by submitting an absentee ballot, but only if the qualified voter satisfies the conditions precedent to meet the requirements of one of the 4 limited exclusive circumstances under which absentee voting is authorized under the Pennsylvania Constitution. Petition paragraph 16. Petitioners allege that mail-in voting in the form implemented through Act 77 is an attempt by the legislature to fundamentally overhaul the Pennsylvania voting system and permit universal, no-excuse mail-in voting absent any constitutional authority. Petitioners argue that in order to amend the Constitution, mandatory procedural requirements must be strictly followed. I just wanted to do an aside here real quick before I go on. It seems really interesting to me that both in this state, which is Pennsylvania, where you have this Act 77 that was put into place, and from what I can gather, it wasn't voted on by the legislature, which we'll get into further in this document, which is part of the mechanism that has to be done to change any laws about voting. That wasn't done in Pennsylvania, and also in Georgia, the same. It appears that a similar thing was done, in which something was changed in the way that Georgia was going to handle certain ballots, right? Very close to right before the election. On top of which, they instituted the Dominion system, which they had never used in any previous election before. And so they instituted that as well. So there's a double thing in Georgia going on. I just wanted to point that out before I read further on into this document, the judge's opinion. So thanks for that, guys. So specifically, pursuant to Article 11, Section 1, a proposed constitutional amendment must be approved by a majority vote of the members of both the Pennsylvania House of Representatives and Senate in 2 consecutive legislative sessions. Then the proposed amendment must be published for 3 months ahead of the next general election in 2 newspapers in each county. And finally, it must be submitted to the qualified electors as a ballot question in the next general election and approved by a majority of those voting on the amendment. According to petitioners, the legislature did not follow the necessary procedures for amending the Constitution before enacting Act 77, which created a new category of mail-in voting. Therefore, the mail-in ballot scheme under Act 77 is unconstitutional on its face and must be struck down. As relief, petitioners seek inter alia, a declaration and or injunction that prohibits respondents from certifying the November 2020 general election results, which include mail-in ballots that are permitted on a statewide basis and are allegedly improper because Act 77 is unconstitutional. You know, that's the thing, right? How can you rush to certify this when you still have pending legislation and litigation going on in your court system within your state? This particular thing, and the same in Georgia, and it seems like in Michigan, where they just like sort of were rushing to certify. I mean, you can't do that, right? How can you certify if a group is coming forward and saying that you've changed the actual constitution of our state, the laws of our state, without in a way that's not, in our constitution? And that's what it appears happened in Pennsylvania, because were all these things followed? Was it voted on in a previous election? Was it taken out in 2 newspapers in each county? Was that done? If that wasn't done, then it's null and void in a sense, is what they're saying, because you didn't follow the laws of the state and what they dictate how you have to go about changing anything having to do with the voting in the state and how it's handled and how absentee ballots and certain ballots are handled. So I think that's where this is headed here. It's challenging the actual these things that were put into place right before the election, which is highly dubious at best, and at worst looks to be like a mechanism that you're trying to put in place to insert a lot of extra ballots into the race, right? And I'm going to get into that a little later, how the Brennan Institute and certain people were recommending that each state have a certain amount of emergency ballots on hand. Well, why you have so many blank emergency ballots on hand and envelopes for unless you're going to try to insert them at some point into the race. That's the allegation now in multiple states. So, sorry for that aside. Let's read on. On November the 22nd, 2020, petitioners filed a motion for emergency special prohibitory injunction, emergency motion, and a memorandum of law in support of the emergency motion. In the emergency motion, petitioners seek to enjoin respondents from taking official action to tabulate, compute, canvass, certify, or otherwise finalize the results of the November 3rd, 2020 general election. They submit that this court must intervene immediately in order to prevent irreparable injury from the resulting wrongs of an election conducted pursuant to an unconstitutional and invalid mail-in ballot voting scheme. Motion at 2. They claim their right to relief is clear, and they are likely to succeed on the merits because they have showed that a substantial legal question must be resolved to determine the rights of the parties. So, there it is right there. Interesting. They contend that the Pennsylvania Constitution requires voting to take place in person, subject only to specified absentee voting exceptions. They point out that Article 7, Section 14 provides the only such exceptions to in propria persona voting requirement of the Pennsylvania Constitution in 4 specific circumstances. It states, A, the legislature shall by general law provide a manner in which and the time and place at which qualified electors who may, on the occurrence of any election, be absent from the municipality of their residence, because their duties, occupation, or business require them to be elsewhere, or who, on the occurrence of any election, are unable to attend at their proper polling places because of illness or physical disability, or who will not attend a polling place because of the observance of a religious holiday, or who cannot vote because of election day duties. In the case of a county employee, may vote and for the return and canvass of their votes in the election district in which they respectively reside. B, for purposes of this section, municipality means a city, borough, incorporated town, township, or any similar general purpose unit of government which may be created by the General Assembly. Pennsylvania Constitution, Article 7, Section 14. Petitioners argue that outside of the aforementioned prescribed situations, the Constitution does not provide a mechanism for the legislature to allow for expansion of absentee voting. Consequently, Act 77 is illegal and void ab initio because it attempts to expand the constitutionally established exceptions to in propria persona voting requirements. According to petitioners, Act 77 did this by creating a false distinction between the existent absentee voting, quote-unquote, and mail-in voting, quote-unquote, and absentee voting is only constitutionally authorized under the 4 limited circumstances specifically delineated in Section 14. Petitioners contend that without an immediate temporary injunction, Pennsylvania's electoral votes will be cast, electors will be appointed, and this court will lose any authority to provide relief to petitioners. Petitioners argue that greater injury will result from allowing the certification of election results pursuant to an unconstitutional no-excuse mail-in voting scheme than from prohibiting it. Specifically, they contend that no voters will be disenfranchised by the result of a slight delay in certifying the results. Conversely, they argue if the limited injunction is not granted, the harm to all Pennsylvanians is irreparable because they will suffer the fruits of an unconstitutional election. Wow, this is getting into it, huh? By order of November 22nd, 2020, this court observed that petitioners had not properly served a petition upon the respondents, directed service of the petition in the court's order in accordance with Rule 1514 of the Pennsylvania Rules of Appellate Procedure. Sorry, guys. I'm trying to have my coffee, too. File proof of service thereof with the prothonatory by 10 a.m., Monday, November the 23rd, 2020. Upon filing of the proof of service, the court scheduled an expedited telephonic status conference with all counsel of record and represented parties for November 23rd, 2020 at 3. So this is some of the backstory of how this all went down and how the parties were contacted. The Secretary of the Commonwealth and the Governor not certified the results of the November 5th, 2020 general election. Indeed, during the course of the status conference, counsel for respondents stated to this court that the Secretary was only in the process of certifying the results of the election. Following the status with the counsel, the court entered an order on November 23rd, 2020, directing respondents to file preliminary objections directing the DNC Services Corporation, Democratic National Committee. So that's interesting. The DNC Services Corp is a corporation. So does that mean the DNC is a corporation? And should it be? If it is, I don't think it should be, right? Proposed intervener to file an amicus curiae brief in support of its proposed preliminary objections filed with the court, and further directing petitioners to file answers and briefs in opposition to the preliminary objections. The parties were asked specifically to address the application of Section 13(1), 2, and 3 of Act 77, and whether a party is permitted to challenge the constitutionality of Act 77 in any court subsequent to the expiration of the 180 days. Pre curiam order November 23, 2020 at 1. Pursuant to the court's November 23, 2020 order, the Pennsylvania General Assembly filed its preliminary objections and a memorandum of law in support thereof, and Secretary Kathy Bookvar, Secretary the Honorable Thomas Wolfe, and the Commonwealth of Pennsylvania, collectively, executive respondents, together filed preliminary objections and a brief in support thereof. Proposed intervener has filed an amicus brief in support of its preliminary objections. By order of November 24, 2020, this court, upon further consideration of petitioner's emergency motion, ordered respondents to file and serve answers to petitioner's emergency motion, and directed that proposed intervener may file a brief as amicus curiae in opposition to petitioner's emergency motion by 12:30 p.m. on the same date. Petitioners complied with the court's order and filed answers. Let's see this footnote. On November 23, 2020, the DNC Services Corp. DNC Committee sought leave to intervene in this matter. As of the filing of this memorandum opinion, the court has not yet ruled upon proposed intervener's motion for leave to intervene. So the DNC is trying to get involved in this now. They're trying to get in here. The court notes, however, that proposed intervener filed proposed preliminary objections to the petition with this court on November 23, 2020. Sorry, so I got off track, guys. Petitioners complied with the court's order and filed answers and briefs in opposition to the General Assembly's and executive respondents' preliminary objections. The General Assembly and executive respondents have filed their respective answers to the petitioner's emergency motion, and executive respondents also filed a brief in opposition to the emergency motion. Finally, proposed intervener filed an amicus curiae brief in opposition to petitioner's motion. Footnote 3. Petitioner's emergency motion was thus ripe for disposition by order and opinion. However, the very next morning after the status conference on November 24, 2020, the executive respondents filed a brief with an appended press release dated 11/24/20 from the Department of State. Executive respondents in opposition to motion for emergency injunction Exhibit A. The press release stated that following certification of the presidential vote submitted by all 67 counties late Monday, the Secretary today certified the results of the November 3rd election in Pennsylvania for President and Vice President of the United States, unquote. The press release, as respondents' briefs assert, that certification only occurred regarding the results for President and Vice President. Based on this information in the press release, respondents argue the entire dispute is moot. A review of the department's website did not contain any additional information regarding the status of the certification process, nor the entry of any formal public record of such certification. Also, nothing was entered regarding certification of the election results. The court notes that proposed amici curiae, Christine Todd Whitman, John Danforth, Lowell Weicker, Constance Morella, Christopher Shays, Carter Phillips, Stuart Gerson, Donald Iyer, John Bellinger III, Edward J. Larson, Michael Stokes, Paulson, Alan Charles Raoul, Paul Rosenzweig, Robert Shanks, Stanley Twardy, Keith E. Whittington, and Richard Bernstein, proposed amici curiae, have filed an application for leave to file amicus brief in opposition to petitioner's motion application. Proposed amici curiae have attached a brief in opposition. So they're bringing in some heavy people, it looks like. Maybe the DNC is. On November the 25th, 2020, petitioners responded to executive respondents' brief. Let's try to skip forward here and get to the juicy part. Let's see. In opposition to motion for emergency injunction and press release by filing a supplemental application for emergency relief, which raises additional compelling concerns and questions of fact in support of their underlying petition. Okay. Let's skip on ahead here a little. It's talking about that the press release, the dispute was not moved because the certification process for the presidential and vice presidential elections had not been perfected, because there were additional steps that needed to be completed, including issuance of commissions to persons elected pursuant to 25 PS 3160, issuance of certificates, election, and transmission of such certificates to the Speaker of the House of Representatives of the United States in the case of the election of representatives in Congress pursuant to 25 PS 3163. So they're saying that they haven't gone through the full process, right? They haven't been declared elected thereto. The making and filing of certificates for all such elections, the issuance of commissions for all such elections, and the issuance of commissions for each election of judge of every court pursuant. So it sounds like there's an issue as to, like, have you certified the full results? There's an issue, or not, right? Accordingly, in careful consideration of the exigencies and time constraints in this matter of statewide and national import, and the long-standing constitutional mandate that every citizen of this Commonwealth is entitled to no less than a fair and free election, it was necessary to preliminarily enjoin on an emergency and temporary basis executive respondents from undertaking any other actions with respect to the certification of the results of the presidential and vice presidential elections, if indeed anything else needs to be done, pending an evidentiary hearing to ascertain the facts of this matter and to determine if the dispute is moot. Inasmuch as the Secretary had not certified the remaining results of the 2020 general election, it was also necessary to enjoin on an emergency and preliminary basis any attempt to certify these results as well. In light of the factual, constitutional, and legal issues raised, it was incumbent upon the court to immediately enter such emergency preliminary injunction to maintain the status quo and ensure that all of the parties and the citizens of the Commonwealth of Pennsylvania were not denied their right to a fair and free election. Based upon the record before it, this court has sufficient grounds to enjoin respondents from further certification activities on an emergency preliminary basis, pending the results of the evidentiary hearing it had scheduled for this date, after which the court would have determined if a preliminary injunction should issue. Since the court is sitting in equity, it has the power to fashion such relief, as it is vitally important that the status quo be preserved pending further judicial scrutiny. It goes on to say there's no more harm to the respondents by doing this, and the safe harbor provision of 3 U.S.C. 5 does not expire until December 8th, 2020, and the Electoral College does not vote for president and vice president until December 14th, 2020. Additionally, petitioners appear to have established a likelihood to succeed on the merits because petitioners have asserted the Constitution does not provide a mechanism for the legislature to allow for expansion of absentee voting without a constitutional amendment. Petitioners appear to have a viable claim that the mail-in ballot procedures set forth in Act 77 contravene Pennsylvania Constitutional Article 7, Section 14, as the plain language of that constitutional provision is at odds with the Mail-in Provisions Act of Act 77. Since this presents an issue of law which has already been thoroughly briefed by the parties, this court can state that petitioners have a likelihood of success on the merits of its Pennsylvania constitutional claim. Without the emergency relief ordered by this court, there would be the likelihood of irreparable harm to petitioners. As to Petitioner Kelly, although it appears that he gained the most votes in the election for the office he seeks, that result has yet to be certified. Further, he may suffer irreparable harm prospectively should he seek election to public office in the future, if what may be an unconstitutional mail-in voting process remains extant. Such mail-in ballots may make the difference as to whether he is successful or not. As to petitioners Parnell and Logan, mail-in ballots may have made the difference as to whether they have won or lost their respective elections. Hence, their fates may well turn upon the constitutionality of Act 77. The other voters in this case assert their constitutional voting rights as citizens of Pennsylvania would be irreparably harmed. Conversely, since the relief ordered by the court is on an emergency basis, respondents face no irreparable harm. In any event, the matter of irreparable harm would have been assessed at the evidentiary hearing. The relief ordered by this court is also in the public interest. Any claim that the voters of this Commonwealth are disenfranchised by this court's order are spurious. The order at issue does nothing more than preserve the status quo pending further and immediate review. That being said, this court is mindful that one of the alternative reliefs noted by petitioners would cause the disenfranchisement of the nearly 7 million Pennsylvanians who voted in the 2020 election. Specifically, respondents claim that a temporary stay would disenfranchise voters as the legislature would appoint the electors to the election college. However, as noted, the legislature is not authorized to appoint the electors to the Electoral College until December 8th, the federal safe harbor quote-unquote date for certifying results for presidential electors. The court agrees it would be untenable for the legislature to appoint the electors where an election has already occurred if the majority of voters who did not vote by mail entered their votes in accord with the constitutionally recognized method, as such action will result in the disenfranchisement of every voter in the Commonwealth who voted in this election. Not only those whose ballots are being challenged due to the constitutionality of Act 77. However, this is not the only equitable remedy available on a matter which hinges upon upholding a most basic constitutional right of the people to a fair and free election. Hence, respondents have not established that greater harm will result in providing emergency relief than the harm suffered by the public due to the results of a purportedly unconstitutional election. U.S. Supreme Court has addressed various circumstances concerning disenfranchisement of voters. For instance, it has held the right to vote is foundational to our republic, and this fundamental right, quote, can be denied by a debasement or dilution of the weight of a citizen's vote just as effectively as by wholly prohibiting the free exercise of the franchise, unquote. Reynolds v. Sims, 377 U.S. 533, 555, 1964. Reynolds, which established the one-person, one-vote doctrine, is the seminal case on voter dilution. Under this concept, a mail-in voting process that would exceed the limits of absentee voting prescribed in Pennsylvania Constitution, Article 7, Section 14, could be construed as violating the one-person, one-vote. In that event, the sheer magnitude of the number of mail-in ballots would not be a basis to disregard not only this provision of the Pennsylvania Constitution, but also the one-person, one-vote doctrine, established by Reynolds, one of the bedrock decisions of the U.S. Supreme Court. For all of the above reasons, the court respectfully submits that the emergency preliminary injunction was properly issued and should be upheld pending an expedited emergency evidentiary hearing. Patricia A. McCullough, Judge. So as you can see, they're challenging the actual constitutionality of Act 77. Is it legal? And it doesn't appear to be from the arguments made by the judge and in her opinion. It seems like it's not legal and that it was changed in a way that was illegal because it was supposed to be changed by the in a certain process, and that process doesn't appear to be followed, right? The two newspapers in each county and also having it being voted on in a previous election first as a ballot amendment or something on the ballot. I don't believe either one of those things were done. And the way that they did this so close to the election is just dubious at best. So I wanted to jump into Georgia for a second because this article came up about something that I was... hang on a second, let me backtrack. Georgia. Right. So Georgia continues to tempt fate this election season. This was from the Brennan Center for Justice, and I'm not aware of what this center is or who it's affiliated with, but it was pulled up in I believe it was in this one of the Did Democrats recommend pre-printed ballots and provisional envelopes for up to 40% of registered voters to be on hand so they could steal election for Biden? One question from the 2020 election is, how did states like Georgia, which were behind by 100,000 votes on election night, find enough votes after the polls closed to steal the election for Biden? We have uncovered at least one element in how this was possible. we've reported for the last few weeks how states like Michigan, Pennsylvania, Wisconsin, Georgia, and Virginia flipped the election for Biden after they stopped counting, added hundreds of thousands of votes for Biden, and then kept all votes after that period in time at the same ratio of Biden to Trump, with Biden always leading at the same percent. So you can see we caught them part 7, Wisconsin, like Michigan, Georgia, Pennsylvania, and Virginia caught doing the drop and roll too. Once Biden gained lead with massive vote dumps, the rest of votes all possess same Biden to Trump vote ratio. This is impossible. And this starts making me think that like they definitely were using like the gem system as well as dumping votes in, because for it to rise at a ratio like that, you can program stuff in like that, like I was talking about in other videos, where like Bev Harris was saying, you can only get 42%, or you can make it that, you could have weighted averages set in and turn everything into decimals, where like, yeah, it'll make it so every vote for Biden is 1.25 and every Trump vote is 0.75. You could do it that way, where Trump's votes aren't even 1 and 1 anymore. And this gets back to the fact that of disenfranchising the voters and making not, is it one vote, one person anymore, right? If this system is allowing me to, or you can inject ballots that are on hand into the system to take my vote out in a sense, right? And make my vote not mean anything if you can put a fake ballot in for Biden and then nullify certain people's votes. This drop and roll scenario was depicted in a video at TGP, Gateway Pundit. You can go check that out, drop and roll. One question is how were they able to do this physically? Where did they find the votes? Well, we have found the answer to this in at least one state that we believe may have carried over to the other states stolen for Biden. Brennan Center for Justice recommended in late September that states should carry an incredible number of ballots on Election Day. To be sufficient, there should be enough emergency and provisional materials to keep voter lines moving for up to 3 hours, while any technical issues can be identified and be resolved. In 2020, this will likely require precincts to have enough backup materials for 40% of all Election Day voters. By late October, they were recommending more of the same in states like Georgia. Georgia regulations already require keeping emergency paper ballots on hand, as well as configuring polling place scanners to accept both machine-printed ballots and emergency ballots. The regulations mention a bare minimum amount equal to 10% of all registered voters. However, this is simply insufficient to cover 3 hours of voting on Election Day. The lines we saw this week during early voting in Georgia confirm what was already known. November's elections are likely to see historic turnout. Backup ballots are necessary not only in response to machine failures, but also for provisional voting. When voters find themselves in the wrong polling place, or when they've requested an absentee ballot but wish to vote in person and a poll manager isn't available to help. To cover all these scenarios, Georgia election officials should supply Election Day polling places with enough pre-printed ballots and provisional ballot envelopes for 40% of registered voters, and they should provide at least some backup supplies at early voting sites too. Come Election Day, the Democrats were getting crushed by President Trump's historic turnout and massive vote totals. They had to do something, so they stopped all counting and brought in hundreds of thousands of ballots for Joe Biden. We know now where they found enough ballots sitting around that they could use to manufacture these votes for Biden. Democrats ensured they would be there before the election. And if you notice, the L. Lynn Wood case is asking for a particular set of video that is from a particular polling center, I believe in Atlanta. And that's going to be interesting, because I heard a rumor that Stacey Abrams, and this is a rumor, had participated in part of that, getting some of those ballots together, those fake ballots. And that's an allegation I heard. We'll see how that pans out into truth or not. But somebody, the allegation is, injected a bunch of ballots in during that particular shutdown, which was apparently for a water leak that turned out to not be a major leak at all. But the allegation that I think L. Lynn Wood is making is that certain areas were cleared out of people while this leak was dealt with for a certain period of time in which the vote was stopped. And his allegation, I think, is to the effect of that during that vote stoppage in Georgia, it was the time taken so they could assess how much Biden was down and then inject whatever votes were needed into the system to bring him up into the lead. And then little by little, as it went on, to use the incremental system to make sure he stayed in that lead. So that's kind of where we are. It seems like to me. And you could see that a pattern is here where in some of these states, like particularly Pennsylvania and Georgia, it appears that people, either the Secretary of State in each state and along possibly with the governor, help, which would be, I would think, be needed in that, and possibly the DNC now we're seeing, right, who's trying to intervene into this case. But it appears that in both these states that somebody attempted to change the way that absentee ballots and certain ballots were handled, which is illegal in those two states. That has to be done through the legislature, has to be voted on, and certain procedural things have to be done, like we read in Pennsylvania, where each county has to, you have to vote on this in a previous election first. It has to go through a process, and then it has to be in the newspapers, and all these things have to be followed. And the question, I think, in Pennsylvania and Georgia is going to be, were those things followed? And was, in other words, this emergency relief is being put into place because what the governors of these states are trying to do is just sign off on this before these lawsuits have been, gone through their proper court processes, which is, I would think, illegal, right? Because how can you certify the state if the other one side's saying, hey, wait a minute, we have a challenge here. We are challenging this election and the result of it, and we think that there's some wrongdoing here. So I think that's where we are at this point. Here's another article from Washington Post, October the 2nd, 2020. The Cybersecurity 202, a fight over how Georgia votes comes to a head just weeks before Election Day, with Tanya Riley. And I don't usually share Washington Post, but once in a while they might get it right? So we got to keep checking them and see what they're doing. We got to hold them to task, too. A federal judge could rule as early as today in a legal fight that might upend how Georgia runs November's election. The dispute centers on a last-minute software update that Georgia officials ordered on voting machines across the state, and I hadn't heard about this. The update was prompted by a technical glitch that in some cases hid the names of some candidates in a 21-candidate special election for the U.S. Senate. Plaintiffs in a long-running legal case say the last-minute change could create new hacking vulnerabilities and argue there's not enough time to test for other bugs that will make the machines malfunction during voting. They're asking a judge to order the state to replace the machines with hand-marked paper ballots, which experts say are the most secure option and dramatically lower the chance of technical foul-ups. The pressure's on with less than 2 weeks before early in-person voting begins in Georgia and just over a month until Election Day. Having an election that at the end of the day everyone can say this was the safest, most reliable option, that should be what we all want, David Cross, an attorney with Morrison and Forsters, who's representing the Georgia voters who brought the case, told me. Not going into an election with entirely new software that was written over a weekend. The late-in-the-game software glitch may be the best opportunity for election integrity experts to fully switch to paper ballots. There's a long-standing conflict over the security of the type of machines used in Georgia, called ballot marking devices. Georgia is one of the few states that has a statewide contract for the machines, with which people cast their votes on a touch screen that then produces a paper ballot. Proponents for the machines say they're more efficient than hand-marked ballots, less prone to unintelligible votes, and can be used by people with disabilities that prevent them from filling out paper ballots. Critics say the machines are too complicated or prone to malfunctioning and raise the chances hackers could change people's votes without them not noticing if they don't review the printed out ballot. And with an incredibly tight presidential race, it would just take problems with a few machines to sow doubts about the election's integrity. That undermines the core of what voters need from an election system. Alex Haldeman, an election security expert and computer science professor at the University of Michigan, and an expert witness for the plaintiffs, told me. They need an assurance that votes are going to be counted correctly and that the outcome will be legitimate. So, you can read that article all the way through. It's basically starting to look like, what was this program, right? What was this thing that they set up in Georgia right before the end of the election started, right? It seemed like there was a patch put in, some kind of technical update, or so, we got to figure this all out, right? It just seems like Georgia and particularly Pennsylvania are particularly dubious cases here, where the law may have not been followed and their actual, the way they handle the ballots have been changed. So We'll have to see how that all plays out, guys. Sorry about another long vid, but we got to cover these legal documents because that's how they operate in the courts. And all the courts in the world and all the banks are under maritime admiralty law, as well as some religions. So, which is why, like, some churches are called a denomination, which is money, right? So we have to understand the mechanisms they use to control and how they're. But we can also use the same mechanisms to defeat them because we have the law on our side, we have the Constitution on our side, and each state has its own Constitution and its own laws that are there for a reason to make sure that they have a fair and free election. So, and that each person's vote counts and you get one vote, one person. That's what this is really about. And so with that, guys, I appreciate you listening, and I'll include all the links to everything you can go through at your own leisure. So with that, guys, I wish you well and peace and love. And this is Ash, WAT News, signing off.